Preface, Section 101 and Section 102 of Copyright Law of the United States and related laws contained in Title 17 of the United States Code. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Elsie Selwyn. Copyright Law of the United States and related laws contained in Title 17 of the United States Code by the United States Government. Copyright Law of the United States and related laws contained in Title 17 of the United States Code. The Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. United States Constitution, Article 1, Section 8. Preface. This publication contains the text of Title 17 of the United States Code, including all amendments enacted by Congress through June 30th, 2016. It includes the Copyright Act of 1976 and all subsequent amendments to copyright law, the Semiconductor Chip Protection Act of 1984, as amended, and the Vessel Hull Design Protection Act, as amended. The Copyright Office is responsible for registering intellectual property claims under all three. The United States copyright law is contained in Chapters 1 through 8 and 10 through 12 of Title 17 of the United States Code. The Copyright Act of 1976, which provides the basic framework for the current copyright law, was enacted on October 19, 1976, as Public Law No. 94-553, 90, Statute 2541. The 1976 Act was a comprehensive revision of the copyright law in Title 17. Listed below in chronological order of their enactment are the Copyright Act of 1976 and subsequent amendments to Title 17. Chapters 9 and 13 of Title 17 contain two types of design protection that are independent of copyright protection. Chapter 9 of Title 17 is the Semiconductor Chip Protection Act of 1984, SCPA, as amended. The SCPA was enacted as Title III of Public Law No. 98-620, 98, Statute 3335-3347, on November 8, 1984. Chapter 13 of Title 17 is the Vessel Hull Design Protection Act, VHDPA, as amended. The VHDPA was enacted on October 28, 1998, as Title V of the Digital Millennium Copyright Act, DMCA, Public Law No. 105-304, 112, Statute 2860, 2905. Subsequent amendments to the Title 17 provisions for SCPA and the VHDPA are also included in the list below in chronological order of their enactment. In some cases, statutory enactments affecting copyright law are not codified in Title 17. For transitional and supplementary provisions that do not amend Title 17, see the appendices. Significant copyright legislation enacted since the last print edition of this circular in December 2011 includes the Unlocking Consumer Choice and Wireless Competition Act and the STELA Reauthorization Act of 2014. Statutory enactments contained in Title 17 of the United States Code. Copyright Act of 1976, Public Law No. 94-553, 90, Statute 2541, for the general revision of copyright law, Title 17 of the United States Code, and for other purposes, October 19, 1976. Legislative Branch Appropriation Act 1978, Public Law No. 95-94, 91, Statute 653-682, amending subsection 203 and subsection 708, Title 17, United States Code, regarding the deposit of monies by the Register of Copyrights in the Treasury of the United States, enacted August 5, 1977. Amending Section 203 and Section 708, Title 17, United States Code, regarding the deposit of monies by the Register of Copyrights in the Treasury of the United States, enacted August 5, 1977. Copyright Amendments, Public Law No. 95-598, 92, Statute 2549, 2676, amending Section 201E, Title 17, United States Code to permit involuntary transfer under the bankruptcy law enacted November 6, 1978. Copyright Amendments, Public Law No. 96-517, 94, Statute 3015, 3028, amending Section 101 and Section 117, Title 17, United States Code regarding computer programs, enacted December 12, 1980. Piracy and Counterfeiting Amendments Act of 1982, Public Law No. 97-180, 96, Statute 91, 93, amending Section 506A, Title 17, United States Code, and Title 18 of the United States Code, enacted May 24, 1982. Copyright Amendments, Public Law No. 97-215, 96, Statute 178, amending the Manufacturing Clause in Chapter 6, Title 17, United States Code, enacted July 13, 1982. Copyright Amendments, Public Law No. 97-366, 96, Statute 1759, amending Section 110 and Section 708, Title 17, United States Code, regarding the redesignation of registration fees as filing fees and the exemption from copyright liability of certain performances of non-dramatic literary or musical work, enacted October 25, 1982. Record Rental Amendment of 1984, Public Law No. 98-450, 98, Statute 1727, amending Section 109 and Section 115, Title 17, United States Code with respect to rental, lease, or lending of sound recordings, enacted October 4, 1984. Copyright Amendments, Public Law No. 99-397, 100, Statute 848, amending Section 101 and Section 801, Title 17, United States Code to clarify the definition of the local service area of a primary transmitter in the case of a low-power television station, enacted on August 27, 1986. Amendments to the Semiconductor Chip Protection Act of 1984, Public Law No. 100-159, 101, Statute 899, amending Chapter 9, Title 17, United States Code, regarding protection extended to semiconductor chip products of foreign entities, enacted November 9, 1987. Berne Convention Implementation Act of 1988, Public Law No. 100-568, 102, Statute 2853, enacted October 31, 1988. See Appendix M for certain provisions of this Act that do not amend Title 17 of the United States Code. Copyright Amendments, Public Law No. 100-617, 102, Statute 3194, extending for an additional 8-year period certain provisions of Title 17, United States Code, relating to the rental of sound recordings and for other purposes, enacted November 5, 1988. Satellite Home Viewer Act of 1988, Title II of Public Law No. 100-667, 102, Statute 3935, 3949, enacted November 16, 1988. Judicial Improvements in Access to Justice Act, Public Law No. 100-702, 102 Statute 4642, 4672, amending Section 912, Title 17, United States Code, enacted November 19, 1988. Copyright Fees and Technical Amendments Act of 1989, Public Law No. 101-318, 104 Statute 287, enacted on July 3, 1990. Copyright Royalty Tribunal Reform and Miscellaneous Pay Act of 1989, Public Law No. 101-319, 104 Statute 290, enacted July 3, 1990. Copyright Remedy Clarification Act, Public Law No. 101-553, 104 Statute 2749, enacted November 15, 1990. Visual Artists' Rights Act of 1990, Title VI of the Judicial Improvements Act of 1990, Public Law No. 101-650, 104 Statute 5089, 5128, enacted December 1, 1990. Architectural Works Copyright Protection Act, Title VII of the Judicial Improvements Act of 1990, Public Law No. 101-650, 104 Statute 5089, 5133, enacted December 1, 1990. Computer Software Rental Amendments Act of 1990, Title VIII of the Judicial Improvements Act of 1990, Public Law No. 101-650, 104 Statute 5089, 5134, enacted December 1, 1990. Semiconductor International Protection Extension Act of 1991, Public Law No. 102-64, 105 Statute 320, amending Chapter 9, Title 17, United States Code, regarding protection extended to semiconductor chip products of foreign entities, enacted June 28, 1991. Copyright Amendments Act of 1992, Public Law No. 102-307, 106 Statute 264, 272, amending Chapters 3, Title 17, United States Code as described immediately below and by deleting subsection 108I, enacted June 26, 1992, also through an independent provision that does not amend Title 17 of the United States Code. The Act established the National Film Registry under Title II, which is the National Film Preservation Act of 1992. Copyright Renewal Act of 1992, Title I of the Copyright Amendments Act of 1992, Public Law No. 102-307, 106 Statute 264, amending Chapter 3, Title 17, United States Code by providing for automatic renewal of copyright for works copyrighted between January 1, 1964 and December 31, 1977, enacted June 26, 1992. Copyright Amendments, Public Law No. 102-492, 106 Statute 3145, amending Section 107, Title 17 United States Code regarding unpublished works, enacted October 24, 1992. Copyright Amendments, Public Law No. 102-561, 106 Statute 4233, amending Section 2319, Title 18 United States Code regarding criminal penalties for copyright infringement, enacted October 28, 1992. Audio Home Recording Act of 1992, Public Law No. 102-563, 106 Statute 4237, amending Title 17 of the United States Code by adding a new Chapter 10, enacted October 28, 1992. North American Free Trade Agreement Implementation Act, Public Law No. 103-182, 107 Statute 2057, 2114, and 2115, amending Section 109, Title 17, United States Code, and adding a new subsection 104A, enacted December 8, 1993. Copyright Royalty Tribunal Reform Act of 1993, Public Law No. 103-198, 107 Statute 2304, amending inter alia Chapter 8, Title 17, United States Code, enacted December 17, 1993. Satellite Home Viewer Act of 1994, Public Law No. 103-369, 108, Statute 3477, amending inter alia, Section 101, and Section 119, Title 17, United States Code, relating to the definition of a local service area of primary transmitter, enacted October 18, 1994, Uruguay Round Agreements Act, Public Law No. 103-465, 108, Statute 4809, 4973, amending inter alia, Section 104, Title 17, United States Code, and adding a new Chapter 11, enacted December 8, 1994, see Appendix N for the text of certain provisions of this act that do not amend Title 17 of the United States Code. Digital Performance Right and Sound Recordings Act of 1995, Public Law No. 104-39, 109, Statute 336, amending inter alia, Section 114 and 115, Title 17, United States Code, enacted November 1, 1995. Anti-Counterfeiting Consumer Protection Act of 1996, Public Law No. 104-153, 110, Statute 1386, 1388, amending subsection 603C, Title 17, United States Code, and Section 2318, Title 18, United States Code, enacted July 2, 1996. Legislative Branch Appropriations Act 1997, Public Law No. 104-197, 110, Statute 2394, 2416, amending inter alia, Title 17, United States Code, by adding a new Section 121 concerning the limitation on exclusive copyrights for literary works in specialized format for the blind and disabled, enacted September 16, 1996. Copyright amendments and amendments to the Semiconductor Chip Protection Act of 1984, Public Law No. 105-80, 111, Statute 1529, making technical amendments to certain provisions of Title 17, United States Code, enacted November 13, 1997. No Electronic Theft NET Act, Public Law No. 105-147, 111, Statute 2678, enacted December 16, 1997. Sony Bono Copyright Term Extension Act, Title I of Public Law No. 105-298, 112, Statute 2827, amending Chapter 13, Title 17, United States Code to extend the term of copyright protection for most works to life plus 70 years, enacted October 27, 1998. Fairness in Music Licensing Act of 1998, Title II of Public Law No. 105-298, 112, Statute 2827, 2830, amending inter alia, Section 110, Title 17, United States Code, and adding Section 513 to provide a music licensing exemption for food service and drinking establishments, enacted October 27, 1998. Digital Millennium Copyright Act, Public Law No. 105-304, 112, Statute 2860, 2887, Title IV amending Section 108, Section 112, Section 114, Chapter 7 and Chapter 8, Title 17, United States Code, enacted October 28, 1998. This act also contains 4 separate acts within Titles 1, 2, 3, and 5 that amended Title 17 of the United States Code. These 4 acts are each separately listed below. See Appendix B for additional provisions of this act that do not amend Title 17 of the United States Code. WIPO Copyright and Performances in Phonogram Treaties Implementation Act of 1988, Title I of the Digital Millennium Copyright Act, Public Law No. 105-304, 112, Statute 2860, 2861, amending Title 17 of the United States Code, inter alia, to add a new Chapter 12 which prohibits circumvention of copyright protection systems and provides protection for copyright management information, enacted October 28, 1998. Online Copyright Infringement Liability Limitation Act, Title II of the Digital Millennium Copyright Act, Public Law No. 105-304, 112, Statute 2860, 2877, amending Title 17 of the United States Code to add a new Section 512, enacted October 28, 1998. Computer Maintenance Competition Assurance Act, Title III of the Digital Millennium Copyright Act, Public Law No. 105-304, 112, Statute 2860-2886, amending Section 117, Title 17, United States Code, enacted October 28, 1998. Vessel Hull Design Protection Act, Title V of the Digital Millennium Copyright Act, Public Law No. 105-304, 112, Statute 2860-2905, adding Chapter 13, Title 17, United States Code, to provide design protection for vessel hulls, enacted October 28, 1998. Copyright amendments and amendments to the Vessel Hull Design Protection Act, Public Law No. 106-44, 113, Statute 221, making technical corrections to Title 17 of the United States Code, enacted August 5, 1999. Satellite Home Viewer Improvement Act of 1999, Title I of the Intellectual Property and Communications Omnibus Reform Act of 1999, Public Law No. 106-113, 113, Statute 1501, Appendix 1, amending Chapters 1 and 5 of the Title 17 of the United States Code to replace the Satellite Home Viewer Act of 1994, and amending Chapters 12 and 13 of Title 17, enacted November 29, 1999. Digital Theft Deterrence and Copyright Damages Improvement Act of 1999, Public Law No. 106-160, 113, Statute 1774, amending Chapter 5 of Title 17 of the United States Code to increase statutory damages for copyright infringement, enacted December 9, 1999. Work Made for Hire and Copyright Corrections Act of 2000, Public Law No. 106-379, 114, Statute 1444, amending the definition of works made for hire in Title 17 of the United States Code, amending Chapter 7 of Title 17, including changing the language regarding copyright office fees, and making other technical and conforming amendments to Title 17, enacted October 27, 2000. Intellectual Property and High Technology Technical Amendments Act of 2002, Division C, Title III, Subtitle B of the 21st Century Department of Justice Appropriations Authorization Act, Public Law No. 107-273, 116, Statute 1758, 1901, making technical corrections both to Title 17 United States Code and, as described in footnotes where appropriate, to Title I of the Intellectual Property and Communications Omnibus Reform Act of 1999, entitled the Satellite Home Viewer Improvement Act of 1999, Public Law No. 106-113, 113, Statute 1501, Appendix 1, enacted November 2, 2002. Technology, Education, and Copyright Harmonization Act of 2002, Division C, Title III, Subtitle C of the 21st Century Department of Justice Appropriations Authorization Act, Public Law No. 107-273, 116, Statute 1758, 1910, amending Chapter 1, Title 17, United States Code to incorporate provisions relating to use of copyrighted works for distance education, enacted November 2, 2002. Small Webcaster Settlement Act of 2002, Public Law No. 107-321, 116, Statute 2780, amending Chapter 1, Title 17, United States Code to incorporate new language into Section 114, enacted December 4, 2002. Copyright Royalty and Distribution Reform Act of 2004, Public Law No. 108-419, 118, Statute 2341, revising Chapter 8, Title 17, United States Code in its entirety, enacted November 30th, 2004. Individuals with Disabilities Education Improvement Act of 2004, Title III, Public Law No. 108-446, 118, Statute 2647-2807, amending Section 121, Title 17, United States Code to further expand authorized reproduction of copyrighted works for the blind or people with other disabilities, enacted December 3, 2004. Satellite Home Viewer Extension and Reauthorization Act of 2004, Title 9, Division J of the Consolidated Appropriations Act 2005, Public Law Number 108-447. 118, Statute 2809-3393, amending Section 119, Title 17, United States Code, throughout and by extending for an additional 5 years the statutory license for satellite characters retransmitting over-the-air television broadcast stations to their subscribers, enacted December 8, 2004. Anti-Counterfeiting Amendments Act of 2004, Title 1 of the Intellectual Property Protection and Courts Amendments Act of 2004, Public Law Number 108-482, 118, Statute 3912, amending Section 2318, Title 18, United States Code concerning trafficking and counterfeit or illicit labels in connection with stolen copyrighted works, enacted December 23, 2004. Fraudulent Online Identity Sanctions Act, Title II of the Intellectual Property Protection and Courts Amendment Act of 2004, Public Law Number 108-482, 118, Statute 3912, 3916, amending Section 504C, Title 17, United States Code to add language making it a criminal violation to knowingly provide false contact information for a domain name that is used in connection with copyright infringement when registering the domain name with authorities, enacted December 23, 2004. Artists' Rights and Theft Prevention Act of 2005, also known as the ART Act, Title 1 of the Family Entertainment and Copyright Act of 2005, Public Law Number 109-9, 119, Statute 218, amending Chapter 113, Title 18, United States Code to add a new Section 2319B, authorizing criminal penalties for unauthorized recording of motion pictures, amends Section 506A, Title 17, United States Code in its entirety, amending Section 2319, Title 18, United States Code by adding criminal penalties for Section 506A, amending Section 408, Title 17, United States Code by adding new language authorizing pre-registration of works being prepared for commercial distribution, and directing the United States Sentencing Commission to establish policies and guidelines for intellectual property crimes, enacted April 27, 2005. Family Movie Act of 2005, Title II of the Family Entertainment and Copyright Act of 2005, Public Law Number 109-9, 119, Statute 218, 223, amending Section 110, Title 17, United States Code, to add a new exemption from infringement for imperceptible skipping of audio and video content in motion pictures, enacted April 27, 2005. Preservation of Orphan Works Act, Title IV of the Family Entertainment and Copyright Act of 2005, Public Law Number 109-9, 119, Statute 218, 226, amending Section 108I, Title 17, United States Code, to add orphan works to the list of works that are exempt from certain limitations on uses by libraries and archives, enacted April 27, 2005. Copyright Royalty Judges Program Technical Corrections Act, Public Law Number 109-303, 120, Statute 1478, to make clarifying and technical corrections to Chapter 8 United States Code and related conforming amendments, enacted October 6, 2006. Prioritizing Resources and Organization for Intellectual Property Act of 2008, Public Law Number 110-403, 122, Statute 4256, amending civil and criminal provisions in Chapters 4, 5, and 6, Title 17, United States Code, and related provisions in Title 23, United States Code, enacted October 13, 2008. Vessel Hull Design Protection Amendments Act of 2008, Public Law Number 110-434, 122, Statute 4972, amending definitions in Section 1301, enacted October 16, 2008. Webcaster Settlement Act of 2008, Public Law Number 110-435, 122, Statute 4974, amending Section 114 to implement the Webcaster Settlement Agreement enacted October 16, 2008. Webcaster Settlement Act of 2009, Public Law Number 111-36, 123, Statute 1926, amending Section 114 to authorize 30-day negotiation period for webcasters and copyright holders, enacted June 30, 2009. Department of Defense Appropriations Act 2010, Public Law Number 111-118, 123, Statute 3409, amending Section 119, Title 17, United States Code, to extend certain time periods to February 28, 2010, and to repeal Section 4A of the Satellite Home Viewer Act of 1994, enacted December 19, 2009. Temporary Extension Act of 2010, Public Law Number 111-144, 124, Statute 42, amending Section 119, Title 17, United States Code, to extend certain time periods to March 28, 2010, enacted March 12, 2010. Satellite Television Extension Act of 2010, Public Law Number 111-151, 124, Statute 1027, amending Section 119, Title 17, United States Code, to extend certain periods to April 30, 2010, enacted March 26, 2010. Continuing Extension Act of 2010, Public Law Number 111-157, 124, Statute 1116, amending Section 119, Title 17, United States Code, to extend certain time periods to May 31, 2010, enacted April 15, 2010. Satellite Television Extension and Localism Act of 2010, Public Law Number 111-175, 124, Statute 1218, amending Sections 111, 119, 122, 708, and 804 of Title 17 United States Code, enacted May 27, 2010. Copyright Cleanup, Clarification, and Corrections Act of 2010, Public Law Number 111-295, 124, Statute 3180, making miscellaneous, clarifying, conforming, and technical corrections throughout Title 17 United States Code, and Section 2318, Title 18 United States Code, and repealing Section 601, Title 17 United States Code, enacted December 9, 2010. STELA Reauthorization Act of 2014, Public Law Number 113-200, 128, Statute 2059, amending Sections 119 and 122 of Title 17 United States Code, enacted December 4, 2014. Acknowledgements. This 2016 edition would not have been possible without the efforts of Renee Coe, Attorney Advisor in the Office of the General Counsel, and Michelle Cho, Barbara A. Ringer-Feller, who both reviewed and updated the statutory text, as well as visual information specialists David Rice and Cecilia Rogers, and writer-editor Judith Neerman from the Office of Public Information and Education, who finalized the editing, design, and production of this edition. Karen Temple Claggett, Acting Register of Copyrights. Chapter 1, Subject Matter and Scope of Copyright. Section 101, Definitions. Except as otherwise provided in this title, as used in this title, the following terms and their variant forms mean the following. An anonymous work is a work on the copies or phonorecords of which no natural person is identified as the author. An architectural work is the design of a building as embodied in any tangible medium of expression, including a building, architectural plans, or drawings. The work includes the overall form as well as the arrangement and composition of spaces and elements in the design, but does not include individual standard features. Audiovisual works are works that consist of a series of related images which are intrinsically intended to be shown by the means of machines or devices such as projectors, viewers, or electronic equipment, together with accompanying sounds, if any, regardless of the nature of the material objects, such as films or tapes in which the works are embodied. The Berne Convention is the convention for the protection of literary and artistic works, signed at Bern, Switzerland on September 9, 1886, and all acts, protocols, and revisions thereto. The best edition of a work is the edition published in the United States at any time before the date of deposit that the Library of Congress determines to be most suitable for its purposes. A person's children are that person's immediate offspring, whether legitimate or not, and any children legally adopted by that person. A collective work is a work such as a periodical issue, anthology, or encyclopedia in which a number of contributions, constituting separate and independent works in themselves, are assembled into a collective whole. A compilation is a work formed by the collection and assembling of pre-existing materials or of data that are selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. The term compilation includes collective works. A computer program is a set of statements or instructions to be used directly or indirectly in a computer in order to bring about a certain result. Copies are material objects other than phonorecords in which a work is fixed by any method now known or later developed, and from which the work can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. The term copies includes the material object other than a phonorecord in which the work is first fixed. Copyright owner, with respect to any one of the exclusive rights comprised in a copyright, refers to the owner of that particular right. A copyright royalty judge is a copyright royalty judge appointed under Section 802 of this title and includes any individual serving as an interim copyright royalty judge under such section. A work is created when it is fixed in a copy or phonorecord for the first time. Whether a work is prepared over a period of time, the portion of it that has been fixed at any particular time constitutes the work as of that time, and where the work has been prepared in different versions, each version constitutes a separate work. A derivative work is a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which a work may be recast, transformed, or adapted. A work consisting of editorial revisions, annotations, elaborations, or other modifications which as a whole represent an original work of authorship is a derivative work. A device, machine, or process is one now known or later developed. A digital transmission is a transmission in whole or in part in a digital or other non-analog format. To display a work means to show a copy of it either directly or by means of a film, slide, television image, or any other device or process, or, in the case of a motion picture or other audiovisual work, to show individual images non-sequentially. An establishment is a store, shop, or any other similar place of business open to the general public for the primary purpose of selling goods or services in which the majority of the gross square feet of space that is non-residential is used for that purpose, and in which non-dramatic musical works are performed publicly. The term financial gain includes receipt or expectation of receipt of anything of value, including the receipt of other copyrighted works. A work is fixed in a tangible medium of expression when its embodiment in a copy or phonorecord by or under the authority of the author is sufficiently permanent or stable to permit it to be perceived, reproduced, or otherwise communicated for a period of more than transitory duration. A work consisting of sounds, images, or both that are being transmitted is fixed for the purposes of this title if a fixation of the work is being made simultaneously with its transmission. A food service or drinking establishment is a restaurant, inn, bar, tavern, or any other similar place of business in which the public or patrons assemble for the primary purpose of being served food or drink, in which the majority of the gross square feet of space that is non-residential is used for that purpose, and in which non-dramatic musical works are performed publicly. The Geneva Phonograms Convention is the convention for the protection of producers of phonograms against unauthorized duplication of their phonograms, concluded at Geneva, Switzerland on October 29, 1971. The gross square feet of space of an establishment means the entire interior space of that establishment and any adjoining outdoor space used to service patrons, whether on a seasonal basis or otherwise. The terms including and such as are illustrative and not limitative. An international agreement is 1. The Universal Copyright Convention, 2. The Geneva Phonograms Convention, 3. The Berne Convention, 4. The WTO Agreement, 5. The WIPO Copyright Treaty, 6. The WIPO Performances in Phonograms Treaty, and 7. Any other copyright treaty in which the United States is a party. A joint work is a work prepared by two or more authors with the intention that their contribution be merged into inseparable or interdependent parts of a unitary whole. Literary works are works other than audiovisual works, expressed in words, numbers, or other verbal or numerical symbols or indicia, regardless of the nature of the material objects such as books, periodicals, manuscripts, phonorecords, film, tapes, discs, or cards in which they are embodied. The term motion picture exhibition facility means a movie theater, screening room, or other venue that is being used primarily for the exhibition of a copyrighted motion picture if such exhibition is open to the public or is made to an assembled group of viewers outside of a normal circle of a family and its social acquaintances. Motion pictures are audiovisual works consisting of a series of related images which, when shown in succession, impart an impression of motion, together with accompanied sounds, if any. To perform a work means to recite, render a play, dance, or act it, either directly or by means of any device or process, or, in the case of a motion picture or other audiovisual work, to show its images in any sequence or to make the sounds accompanying it audible. A performing rights society is an association, corporation, or other entity that licenses the public performance of non-dramatic musical works on behalf of copyright owners of such works, such as the American Society of Composers, Authors, and Publishers, ASCAP, Broadcast Music Incorporated, BMI, and the SESAC Incorporated. Phonorecords are material objects in which sounds, other than those accompanying a motion picture or other audiovisual work, are fixed by any method now known or later developed, and from which the sounds can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. The term photorecords includes the material object in which the sounds are first fixed. Pictorial, graphic, and sculptural works include two-dimensional and three-dimensional works of fine, graphic, and applied art, photographs, prints, and art reproductions, maps, globes, charts, diagrams, models, and technical drawings, including architectural plans. Such works shall include works of artistic craftsmanship insofar as their form, but not their mechanical or utilitarian aspects are concerned. The design of a useful article as defined in this section shall be considered a pictorial, graphic, or sculptural work only if, and only to the extent that, such design incorporates pictorial, graphic, or sculptural features that can be identified separately from, and are capable of existing independently of, the utilitarian aspects of the article. For purposes of Section 513, a proprietor is an individual, corporation, partnership, or other entity, as the case may be, that owns an establishment or a food service or drinking establishment, except that no owner or operator of a radio or television station licensed by the Federal Communications Commission, cable system or satellite carrier, cable or satellite carrier service or programmer, provider of online services or network access or the operator of facilities therefore, telecommunications company or any other such audio or audiovisual service or programmer now known or as may be developed in the future commercial subscription music service or owner or operator of any other transmission service shall under any circumstances be deemed to be a proprietor. A pseudonymous work is a work with the copies or phonorecords of which the author is identified under a fictitious name. Publication is the distribution of copies or phonorecords of a work to the public by sale or other transfer of ownership or by rental, lease, or lending. The offering to distribute copies or phonorecords to a group of persons for purposes of further distribution, public performance, or public display constitutes publication. A public performance or display of a work does not of itself constitute publication. To perform or display a work publicly means 1. To perform or display it at a place open to the public or any place where it is a substantial number of persons outside of a normal circle of family and its social acquaintances is gathered. Or 2. To transmit or otherwise communicate a performance or display the work in a place specified by Clause 1 or to the public by means of any device or process, whether the members of the public capable of receiving the performances or display receive it in the same place or in separate places and at the same time or at different times. Registration for purposes of Section 205C to 405, 406, 410D, 411, 412, and 506E means a registration of a claim in the original or the renewed and extended term of copyright. Sound recordings are works that result from the fixation of a series of musical, spoken, or other sounds, but not including the sounds accompanying a motion picture or other audio-visual work, regardless of the nature of the material objects, such as discs, tapes, or other phonorecords in which they are embodied. State includes the District of Columbia and the Commonwealth of Puerto Rico and any territories which this title is made applicable by an act of Congress. A transfer of copyright ownership is an assignment, mortgage, exclusive license, or any other conveyance, alienation, or hypothecation of a copyright or of any of the exclusive rights comprised in the copyright, whether or not it is limited in time or place of effect, but not including a non-exclusive license. A transmission program is a body of material that, as an aggregate, has been produced for the sole purpose of transmission to the public in sequence and as a unit. To transmit a performance or display it is to communicate it by any device or process whereby images or sounds are received beyond the place from which they are sent. A treaty party is a country or intergovernmental organization other than the United States that is a party to an international agreement. The United States, when used in a geographical sense, comprises the several states, the District of Columbia and the Commonwealth of Puerto Rico, and the organized territories under the jurisdiction of the United States government. For purposes of Section 411, a work is a United States work only if 1. In the case of a published work, the work is first published, a. in the United States, b. simultaneously in the United States and another treaty party or parties whose law grants a term of copyright protection that is the same as or longer than the term provided in the United States, c. simultaneously in the United States and a foreign nation that is not a treaty party, or d. in a foreign nation that is not a treaty party and all of the authors of the work are nationals, domiciliaries, or habitual residents of, or in the case of an audio-visual work, legal entities with headquarters in, the United States. 2. In the case of an unpublished work, all the authors of the work are nationals, domiciliaries, or habitual residents of the United States, or in the case of an unpublished audiovisual work, all the authors are legal entities with headquarters in the United States, or 3. In the case of a pictorial, graphic, or sculptural work incorporated in a building or sculpture, the building or sculpture is located in the United States. A useful article is an article having an intrinsic utilitarian function that is not merely to portray the appearance of the article or to convey information. An article that is normally a part of a useful article is considered a useful article. The author's widow or widower is the author's surviving spouse under the law of the author's domicile at the time of his or her death, whether or not the spouse has later remarried. The WIPO Copyright Treaty is the WIPO Copyright Treaty concluded at Geneva, Switzerland on December 20th, 1996. The WIPO Performances and Phonograms Treaty is the WIPO Performances and Phonograms Treaty concluded at Geneva, Switzerland on December 20th, 1996. A work of visual art is 1. A painting, drawing, print, or sculpture existing in a single copy in a limited edition of 200 copies or fewer that are signed and consecutively numbered by the author, or in the case of a sculpture in multiple cast, carved, or fabricated sculptures of 200 or fewer that are consecutively numbered by the author and bear the signature or other identifying mark of the author, or 2 is a still photographic image produced for exhibition purposes only, existing in a single copy that is signed by the author, or in a limited edition of 200 copies or fewer that are signed and consecutively numbered by the author. A work of visual art does not include 1. Any poster, map, globe, chart, technical drawing, diagram, model, applied art, motion picture, or other audiovisual work, book, magazine, newspaper, periodical, database, electronic information service, electronic publication, or similar publication. 2. Any merchandising item or advertising, promotional, descriptive, covering, or packaging material or container. 3. Any portion or part of any item described in Clause 1 or 2. B. Any work made for hire, or C. Any work not subject to copyright protection under this title. A work of the United States government is a work prepared by an officer or employee of the United States government as part of the person's official duties. A work made for hire is 1. A work prepared by an employee within the scope of his or her employment, or 2. A work specifically ordered or commissioned for use as a contribution to a collective work, as a part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. For the purpose of the foregoing sentence, a supplementary work is a work prepared for publication as a secondary adjunct to a work by another author for the purpose of introducing, concluding, illustrating, explaining, revising, commenting upon, or assisting in the use of the other work, such as forewords, afterwords, pictorial illustrations, maps, charts, tables, editorial notes, musical arrangements, answer material for tests, bibliographies, appendices, and indexes, and an instructional text is a literary, pictorial, or graphic work prepared for publication and with the purpose of use in systematic instructional activities. In determining whether any work is eligible to be considered a work made for hire under paragraph 2, neither the amendment contained in section 1011D of the Intellectual Property and Communications Omnibus Reform Act of 1999, as enacted by section 1000A9 of Public Law 106-113, nor the deletion of the words added by that amendment, A, shall be considered or otherwise given any legal significance, or B, shall be interpreted to indicate congressional approval or disapproval of, or acquiescence in, any judicial determination. By the Courts of the Copyright Office, paragraph 2 shall be interpreted as if both section 2A1 of the Work Made for Hire Copyright Corrections Act 2000 and section 1011D of the Intellectual Property and Communications Omnibus Reform Act of 1999, as enacted by section 1000A9 of Public Law 106-113, were never enacted, and without regard to any inaction or awareness by the Congress at any time of any judicial determinations. The terms WTO agreement and WTO member country have the meanings given those terms in paragraphs 9 and 10 respectively of section 2 of the Uruguay Round Agreements Act. Section 102. Subject matter of copyright. In general, A. Copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Works of authorship include the following categories. 1. Literary works. 2. Musical works, including any accompanying words. 3. Dramatic works, including any accompanying music. 4. Pantomimes and choreographic works. 5. Pictorial, graphic, and sculptural works. 6. Motion pictures and other audiovisual works. 7. Sound recordings. And 8. Architectural works. B. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. End of copyright law of the United States and related laws contained in Title 17 of the United States Code, Preface, Section 101 and Section 102. Read by Elsie Selwyn.